Well, good morning, everyone. I'm just going to hang on for a minute or so to allow others to join, and then we can get started. Well, good morning, everyone, and welcome to LIDW 21. Today is the final day of the event, and I hope that you have all had a good session so far. Just by way of introduction, I'm Charles Thomson, a partner in Baker McKenzie Dispute Resolution Department. I specialise in general commercial litigation and white-collar crime. And I'm going to be joined by a panel of speakers to talk about our virtual hearings here to stay. I should start, first of all, by thanking the sponsors for LIDW, and particularly a note of thanks to FTI as our platinum sponsor. So thank you very much. Just to provide some context to this event before I introduce the panel, last year there was a joint Baker McKenzie and KPMG initiative to establish views of virtual hearings during the COVID pandemic and in a post-COVID world. But now we're going to discuss not only what the results of that survey was, but also what everyone's experience has been of virtual hearings, and critically, whether or not they're here to stay. There's been some judicial commentary around the virtual hearings, and broadly, I think it's fair to say that people have been in favour of virtual commercial hearings, including the judiciary. So by way of example, last November, the Lord Chief Justice was clearly in favour of virtual hearings, and he confirmed that during the first lockdown, 85% of the work of the commercial and property courts moved to be heard remotely in accordance with their original timetable. So clearly events moved very quickly and were forced to move very quickly during the pandemic. There does seem to have been a slight change in the mood this year as people have become more experienced of the virtual hearings, with court users being less enthusiastic about the use of virtual tech. According to minutes from a user group meeting, the court expects that most trials should take place fully or partly in person from the middle of May this year, apart from Fridays. That's consistent as well with the views of the Bar Council that recognise that the use of remote hearings to deal with shorter, uncontroversial procedural matters is here to stay, but they do note that very careful consideration should be given before any decisions taken to employ remote hearings and trials more widely post-pandemic. They point out that there are significant downsides to virtual hearings, which we'll explore during the course of this discussion. So just before I introduce the panel, we're going to hear views from private practitioners, advocates, experts, and the views of the clients based on the results of the survey that I mentioned earlier. I should say at the beginning that the focus of this discussion is on complex commercial disputes, principally in the UK. It's not based on family law or court of protection disputes or the criminal process, which I think revolves around very different considerations. So if I could turn now to introduce the panel, if I begin with introducing Amanda Brown QC. So Amanda is a partner in KPMG's UK Tax Legal Services team with a wealth of experience as a solicitor advocate, having appeared in every UK court and the CJEU. And she also sits as a part-time judge in the first tier tax tribunal. Having appeared as an advocate before various courts and in mediations virtually, she'll provide her personal insights from an advocate, judicial, and an expert's perspective. Moving on to Heather Murphy. Heather Murphy is an experienced barrister at 24 Old Buildings. She was called to the bar in 2009, has a rich and varied commercial chancery practice with core areas of practice in commercial disputes, as well as private wealth litigation. She's attended virtual court hearings and mediations and is therefore able to offer insights from an advocacy perspective. Turning then to Sarah Murray. Sarah is head of the dispute resolution practice at Stevens Bolton. She deals with a wide range of commercial disputes in the High Court and through arbitration, and will offer practical insights on preparing for and attending virtual mediations and hearings. And finally, last but not least, Henry Garfield. Henry is a partner in the dispute resolution department of Baker McKenzie in London. He's a very experienced commercial litigator with extensive court hearing experience, and he's attended a number of virtual hearings, particularly for urgent interim relief, such as for freezing orders. So let's start with some of the key themes that are going to form the basis for this discussion. The Baker McKenzie KPMG survey that I mentioned earlier and that was conducted last September found that almost 70% would prefer to have virtual interim hearings in the future, with over 65% in favour of all hearings of less than 1 day, not involving cross-examination or very complex documentation. So already there was a feeling amongst those who were interviewed and were part of the survey that to the extent that there was going to be complex hearings involving cross-examination, that perhaps in-person hearings in the longer term would remain preferable. More recently, EY ran a survey where over 80% of the 100 disputes lawyers surveyed indicated that they wanted them to continue post-pandemic, depending though on the complexity of the hearings in question. That's to be contrasted with less than 20% who were in favour of a final hearing being heard remotely, with 48% preferring an in-person hearing. 56% were in favour of hybrid hearings, with some appearing in court and some in person. And finally, just over 70% stated that they believe virtual hearings would accelerate dispute resolution and would be beneficial to their business. So has that been borne out in what we've seen more recently? So let's turn to the vital question, are virtual hearings here to stay? If I could start with Amanda first. Amanda, what's your view on that? Are they really here to stay? And do you find any of those statistics surprising?
Thanks, Henry. So the survey was undertaken last summer. In the first couple of weeks after lockdown started, the courts went into a moment of paralysis. Video and telephone hearings were used in discrete situations for very short applications and usually for the protection of witnesses. Pilot schemes were underway in the tax and the immigration tribunals, but the use of virtual hearings was something for the future. And then the world shifted on its axis, and without doing something, access to justice would go into freefall. In May 2020, I participated in the first ever Supreme Court hearing held virtually. Now that should have been easy, shouldn't it? The Supreme Court has been live streaming for years, but it was logistically complicated. Our counsel was a technical Luddite. BT were digging up the road outside HMRC Council's house, and his children seemed to not be coping with homeschooling particularly well. Later in the month, we did our first tax tribunal. It was uncomfortable and clunky. So by late summer, I probably would not have been a serious advocate for virtual hearings. But 6 months on, I've participated as advocate, instructing solicitor and judge in a wide range of virtual hearings, short applications and an 8-day trial with 3 heavily contested factual witnesses and hot tub experts. The technology issues seem to have been largely overcome. Children are back at school and all participants seem to be comfortable with the forum. So I'm not surprised at the statistics, and I think they are virtually here to stay. They have an important role to play in the administration of justice going forward.
Great.
So Heather, have you noticed any acceleration in the resolution of disputes through virtual hearings?
Thanks, Amanda. I have to say I haven't noticed an acceleration because listing is no quicker. We still have the same number of judges, and although we're not accessing them through the court estate, there's still that same limitation on them. So to that extent, things are being listed as they were, but it's not faster. I actually think that disputes tend to be a little slower because you get less done in a virtual hearing. For whatever reason, they're not as efficient. I think you lose the sort of non-verbal cues that slow things up, even leaving aside technology glitches. So to that extent, I think they're a really useful alternative to keep things going when there was no other alternative. And I see that they've got a role to play going forward where you have witnesses abroad, etc. But I don't think that they're going to suddenly magic some extra judges up to make disputes heard quicker. And to that extent, it's just you're accessing the same court capacity, but just in a different way. But in terms of accessing courts, Sarah, do you think virtual hearings will lead to an increase in solicitors doing more advocacy? Are you going to be pinching my job?
Heather, we would never pinch your job. I don't think you'll necessarily see an increase in solicitor advocates, because that's obviously a sort of big piece of training for us. But I think you might see an increase in solicitor advocacy. And to explain that distinction, as I sort of said, there are a lot of litigators who love being litigators, but they don't want to be counsel or advocates or take your job, because the roles that we perform are very distinct. And I think in high value commercial cases, which we're all concerned with, and particularly for heavy applications and trials, it's always going to be more cost effective and in the client's best interest to instruct you rather than do it ourselves. Having said that, there are some very simple hearings where we currently instruct counsel because it's just not cost effective to send a junior solicitor when you factor in travel and waiting. And the more hearings are online, the more, the less of an issue that travel and waiting time will become. And therefore straightforward applications will be dealt with, I think, in-house from our desks, which is good practice for our juniors. It leads to cost savings and less work potentially for people and very junior barristers. But then, there's one type of hearing where you would never skimp or send a junior, and that's a freezer or urgent injunctive relief. Henry, I was wondering if you'd found virtual hearings quicker and more efficient when applying for that kind of urgent interim relief, and whether judges are more inclined to grant them virtually. Are they more or less probing?
Thanks, Sarah. Good morning, everyone. Well, the short answer to your first question is a resounding yes in my experience. I've worked on several matters that have required remote applications for urgent interim relief. And I have to say, my own view is that this is an area where remote hearings really come into their own, actually, especially when they involve commercial parties who are represented. And I say that because interim applications are often sought on an urgent or semi-urgent basis. They often have less paperwork than a trial and rarely require examination or cross-examination of witnesses. So in my mind, they are very well suited to virtual hearings. Going remote for these types of hearings obviously means that we cut out travel time to court and that element of waiting around in the court building that we all love so much when we're trying to get an urgent application listed. But on my matters, it's certainly easier for us to get counsel's availability because we only had to take up, literally an hour or a couple of hours of their time rather than half a day. And I imagine it's probably easier for us to find a judge as well, because we didn't need a physical courtroom. And so for those reasons, I'm not surprised that our survey results came out the way they did, that 70% of respondents would prefer to have a virtual hearing for the next interim application. In terms of your other questions, whether remote applications interim applications are more likely to be granted and whether they are more probing, I have to say I personally haven't noticed any difference whatsoever. I mean, it would be interesting to see the number of, say, commercial court freezing injunctions granted, whether there was a notably higher or lower number last year than in previous years. But I would be surprised if there was any noticeable difference whatsoever. And based purely on my own experience, there was no difference in the amount of scrutiny or probing that the judge applied to our application. Judges are very used to focusing very clearly on what an advocate is saying, and it was no different when that was done remotely. So I don't think it makes a difference on that front. We were asked exactly the same questions and were subject to the same probing as we would do if we were appearing in person. But I do think that is different if a matter requires a huge amount of documentation or a cross-examination of witnesses. So Sarah, perhaps I can throw a question back to you if I may. We've obviously been focusing totally so far on commercial litigation, but we would get shouted at by a number of people, I'm sure, on the call if we forgot about arbitration. So I know arbitration is an area where remote hearings have been used perhaps more frequently in the past than commercial litigation. But do you think there are different considerations at play for arbitration hearings?
Yeah, it's a good question. I think the answer is, very helpfully yes and no. A lot of the logistical issues are exactly the same. A lot of the problems that they throw up are the same, and I know we're going to come on to talk about those. But there are some additional issues to consider and potential hurdles to overcome. And I'd say, number one, there's a less consistent approach in arbitration. I think the courts have had a 3-line whip that they were going to embrace virtual hearings. And I think even when the immediate sort of emergency is passed, you're going to see sort of central guidance from the courts on how things are going to play out. The major arbitral institutions, they were quick to adjust their rules, and they did try and have that central guidance. But with arbitration, individual arbitrator and party preferences are still going to be a massive factor, and I don't see that changing. Court hearings are on the whole public, but arbitration trades on its confidentiality, and it's often a key reason for the parties choosing it. And I think there are still, whether they're real issues or perceived issues, there's still quite a lot of mistrust around virtual hearings and confidentiality and security, particularly when you've got multiple parties logging on, witnesses, experts, arbitrators, lawyers from their home networks, and how secure those are. And just looking at the security of both the hearing and the data and the documents used in it is going to be a massive concern. I think the other thing, it's not unique to arbitration, but by its very nature, it's international. And so therefore, you're more likely to encounter problems with uneven access to technology from different areas of the world, time zone issues where you've got, witnesses staying up till 2 o'clock in the morning to give their evidence, potentially. And also the need for translators and interpreters, which really, virtual hearings are quite slow anyway, but if you throw those into the mix, it can slow them down even more. On the plus side, you might find more flexibility in an arbitrator's timetable than you would a judge's. And also from an eco point of view, virtual hearings are tremendously much more friendly for the environment. Although I'm not sure how welcome that will be by the arbitration community, who seem to love their international travel. So yeah, that's what I'd say on that.
Thanks, Sarah. Well, we've already touched to an extent on some of the challenges that may accompany these virtual hearings, but let's actually turn to discuss what they are. We've focused very much on whether or not we think they're here to stay, and there seems to be a resounding yes, certainly for the procedural, more straightforward applications, and as regards trial, that's more up to open to debate. But in terms of the key challenges, I'm going to mention one word which everyone will be familiar with: IT. And the question is it more perception than real in terms of the issue? So looking at the theme that came out of the McKenzie KPMG survey, there was definitely a theme that technological issues were the principal concerns around virtual hearings, with 46% saying that IT issues disrupt virtual hearings, and over half saying that the court system will need to invest heavily in tech and training for judges. So perhaps in response to that, this February, as late as this February, it was reported in the Judicial Attitude Survey that 95% of judges now have access to reliable Wi-Fi in their courtrooms. the use of e-bundles rose from 42 to 55%. And while usage of the e-judiciary communication platform shot up from 55% to an incredible 99.8%. So clearly we are moving appropriately with times, with the need to ensure that we can all adapt and make the use of IT. Of course, having a Wi-Fi connection doesn't necessarily mean it's reliable. And even if it's reliable, it doesn't necessarily mean that it gets around other IT related issues. So perhaps if I could start with you, Sarah, in terms of the IT issues. In your view, is it really more of a perception as to whether it's an issue rather than reality? And what's been your experience in preparing for court hearings, such as the preparation of the bundles for counsel, the hearing, the witnesses, and general logistics?
Yeah, I mean, perception rather than reality. IT problems are not problems at all until they actually happen, and then they are the biggest problem you're ever going to have. I think lawyers, I say this about myself as the same as all of you, we're not good with change. And there was certainly a perception at the beginning of all of this that preparing for virtual hearing would just throw up insurmountable technical obstacles. And we're not a profession well known for our IT skills and abilities. The reality, I think, is that a lot of challenges can just be overcome by meticulous preparation and project management. And I think project management is a skill that the modern lawyer needs to have in spades, and that's very evident when it's when we're preparing for a virtual hearing. So practical considerations. I think just making sure all the technology integrates sounds like a basic thing, but we had a trial recently where, for whatever reason, the client didn't want to use the sort of the bundle package that was compatible with Opus 2. So we thought it was compatible, and it wasn't until we got really into the depths of it that we found that there were some ways where it wasn't compatible. And so the time spent devising workarounds, getting everything to work, cost the client far more than the cost of the expensive bundle package. And it gave some of us a lot of grey hair. I think communication is important. You need separate, distinct ways to communicate with counsel, the clients, each other, and then everyone at once. You know, WhatsApp or Zoom chat or whatever it is, but outside the hearing platform, because the last thing you want to do is be messaging your opponents or the judge by mistake. Witnesses need really careful preparation, as they would always need sort of a bit of preparation, but different sorts. So telling them simple things like book yourself a meeting room away from distractions, put a sign on the door telling people to go away, clear your desk, concentrate on the hearing. You know, where should you put the webcam, what's behind you, lighting, all those things become really important for a virtual hearing. And asking the witnesses early about their internet connection and their IT equipment is really important. And I think that the golden rule, unless you are counsel, mute yourself. And if you are counsel, remember to unmute. But yeah, so we've had quite a lot of that.
So thank you. That leads us nicely into Heather. So Heather, from an advocate's perspective, what's your experience been? Has the creation of electronic bundles led to greater efficiencies or caused you more frustration?
Well, hopefully happily unmuted. Bundles, I mean, if done well, they can be useful because you can deploy the full range of sort of Adobe tools in terms of highlighting and comments and extraction. And that's actually incredibly efficient if you're up for that sort of deployment. But if done badly, they are worse than a paper bundle by some degree. And that is everything from pages that aren't in properly, page references that don't work. Duplicates, it's incredibly easy in my experience for these to creep in because you're not physically looking at the bundle thinking, my goodness, this is big, can we fillet it? You're thinking, Adobe would just add more into the PDF. And the bundle has got to be comprehensive because you can't easily add to it. You can't hand documents up in the sort of the way that counsel always does when there are last minute like consent orders and the like. That is gone. And it's not easy when you suddenly have the main bundle, which is all paginated and you've highlighted, and then 3 supplemental bundles cluttering your worktop. That's when you're screen limited, your screen estate is limited, that's quite tricky. So I think that any cost saving that comes by not traveling to court, I think has to be deployed in applying to the bundle to make sure that it actually works.
And how many screens do you have out of interest when you're doing a hearing? Is it 2 or 3?
No, it's a good question. I have 3. It's a minimum 3. A screen for the camera and my notes, a screen for the bundle separately, and then a screen like a phone or the like for how we communicate with solicitors, because Sarah's right, getting the counsel team and the legal team talking to each other is a real challenge. And WhatsApp is not the best option, but it's probably the least worst option. And it's not great because I would never have my phone out in court. Like, it's such a distraction to have these messages pinging up, but there's no other real alternative. And it's also quite challenging because in court, there's a rhythm to it. And solicitors, experienced litigation solicitors, will know, like, all right, here's the point. Counsel's come to the end of the point. Actually, I want to hand a note up. There's that real rhythm where things are deployed in a way that gets them to your attention in a really sensible manner. That doesn't work with WhatsApp because it's fastest fingers first. And so everyone is like, oh, that's a really terrible point. Let me message like counsel. And so you can get inundated with messages that then get lost. And I should say separately that if anyone wants to inundate us, please don't WhatsApp me, but do Q&A us. And that's a real challenge because that really disrupts the flow, as well as the horror of having to watch yourself do advocacy. And sometimes I stick a Post-it note over myself. So you just don't have to look, because that's not good. And it's quite a distraction. And you want to be engaging with the person you're meant to be persuading, not looking at yourself.
So I suppose that comes back to Sarah's point of planning, agreeing between you in advance how you're going to communicate and at what stage. So sometimes it may be unavoidable, but actually waiting until you complete a certain area or subject may be the appropriate time to then send that WhatsApp messages rather than hearing the constant dinging.
Yeah, and the sort of flash up. And it's very difficult because WhatsApp, unless you have a separate work phone, and I think most barristers probably don't, you're messaging them on their personal phone. So with the WhatsApp, you're at risk that their friends and family who aren't on the same sort of timetable as you will also be sending the messages at the same time. And so I think wanting to, I by and large try to not look at my phone as much as possible until I am ready, because I know that if you like, it's an asymmetrical method of communication and people will send me messages and either they will distract me or I have to make sure that they're out of the way until it's a good time to look at them. Because otherwise, I think, and you can see it when your oppo is getting messages up and they sort of look across the other side and they tail off and the judge, they say, oh, no, there's another point. And that's not great advocacy.
And what's been your experience with confidentiality? Do you think it's an issue? Do you think it's more of an issue than it ever has been because of the virtual world in which we now live?
I think it is an issue. And I know that there are large trials which have happened in the commercial court where actually the preference has been for everything to be in paper because it was, if you like, there are fewer leaks. The problem with an electronic bundle is there are a lot of leaky holes. And as soon as you start circulating links, and the more links you circulate, the more leaky holes there might well be. So courts to date have not, in my experience, started court hearings by doing a roll call as to who's there. And that can be quite challenging because you sometimes get telephone numbers that join, and including one hearing I had where a telephone number joined. There were clearly multiple people listening in, and then one of them took a call in the middle of the hearing and didn't mute themselves. So we were all trying to mute them. And it's obviously disruptive from an advocacy point of view, but from a who's listening in, who's there, that's quite opaque because you can't see them. And whether that's a real risk that there's a real leak, or it's simply going to give a client who's concerned about confidentiality collywobbles because it's just an opaque unknown, I think there is a pretty legitimate concern about who is accessing it and what information and how do you control that flow. And that is one of the challenges of the technology.
Thank you. And Henry, in a similar vein, Heather's spoken about this from the perspective of an advocate. What about the client perception of virtual hearings? Do they love them? Do they hate them? Has there been mixed feedback?
Yeah, I think we're looking at this issue from a number of perspectives today, but I do think the client perspective is an incredibly important one, because at least in relation to the type of work we do, those clients are often international corporates who have a choice where in the world they litigate. So if London is not offering them what they want, they'll head off to New York and Singapore, who will offer them what they want. So I think that's certainly one reason why we need to ensure that the client experience is as good as possible for the sort of clients we work with, Charles. And in my experience, I've found the client views on virtual hearings to be pretty mixed, actually. Some obviously love the cost savings and the efficiency of the virtual hearing process. There are also clients who just, quite frankly, don't want to get dressed up and traipse into London for a hearing or a trial. They like the freedom of being able to sit in their living room on mute, screaming at the screen and furiously messaging everyone else on the team, much to Heather's annoyance, it sounds like. But the flip side of that is I think there are definitely clients who literally want their day in court. And I found this particularly so with clients from overseas who have chosen London as a place to resolve their disputes. And they want to see justice physically being done in a physical courtroom. And I've spoken to clients who really do like the pomp and ceremony that they see that comes with English litigation, the wigs, the gowns, the robes. And they feel like a lot of that is missing when they just see people through a screen. So I think, like a lot of the issues we're talking about today, it really depends. But I do see that for some clients, there is a risk that the client experience is a little bit damaged by remote hearings, perhaps because being sent a link to your hearing and dialing in might not be the same as turning up to a grand old court at, in the RCJ, for example. So I do think that's an issue.
Yeah. And one of the core benefits I've found, certainly of interim hearings as a solicitor, is that you can have constructive discussions, whether before, during, or after a hearing with your opposition. That's obviously made a lot more challenging in the virtual world now. Is that something that you have noticed has caused a more of a challenge? And if so, how can we try to work around that to redress the balance?
Well, the short answer to that is yes. I'm sure all of the solicitors amongst us have had very constructive conversations with opposing solicitors outside the physical courtroom, either before, during, or after a hearing. And I'm sure Heather and Amanda and the other barristers on the call would say the same about counsel to counsel discussions. And I think those types of conversations are really, really good at often resolving the issue that is before the court, or at the very least, it's enabled us to flesh out exactly what the issue is we're fighting about, and what is actually motivating the other side. And nothing else, it enables you to size up the other side, literally or metaphorically. But so there's obviously nothing to prevent me from picking up the phone to the solicitor on the other side, either before, during, or after a hearing. But I'm just finding that those types of conversations just aren't coming as naturally and as organically as they used to in the physical court scenario, which I actually do think is an issue. So I think it's incumbent on us all as legal advisors to just get used to trying to replicate those types of conversations when we're having virtual hearings, as we would with physical hearings, because I do think they're a big part of the dispute resolution process.
And how about witness testimony? How's that been impacted? I think that's probably one of the most controversial questions.
Yeah, I do think that witness testimony is one area that is a very significant challenge for remote hearings. And I know witnesses have given evidence remotely in a number of scenarios before the pandemic. But I do think that they have always come with challenges. And I think one challenge is as we've touched on already, logistics and technologies. As soon as you throw into a mix an interaction between a barrister and a witness might be overseas who's using home Wi-Fi with occasional interruptions from a judge on the other side. Add into that, as we often find with our case of Charles, a translator is required. You might have a translation either happening at the end of the witness or in London. The risk of something going wrong, I think, increases quite dramatically. And then you also have to factor in the risk, whether it's real or perceived. I'm not quite sure that a remote witness has a greater opportunity to access notes or assistance when they're giving evidence that obviously wouldn't be available to them when they're in court. And I do think there is also a risk, again, whether it's perceived or real, I don't know, that the witness might not get the importance and the seriousness of what it is they are doing if they're doing it from their living room as opposed to standing up in an old wooden courtroom physically in front of a judge. I think that is a little bit of a risk as well. And I think there are ways we can mitigate those risks by judges conducting checks and giving appropriate warnings. But I do think it's an area that we as a legal profession generally have to be very careful that we monitor, because I think it is a risk area. And I think it's probably one of the main reasons why there seems to be a growing consensus that the best place for full trials is the physical courtroom.
Yeah. Okay. Thanks, Henry. Well, on the topic of witnesses, let's turn to expert witnesses. So, Amanda, working at KPMG, you're obviously very used to working closely and in conjunction with experts. What have their views been in terms of giving evidence virtually?
I've had extensive conversations with them. Their experience is actually overwhelmingly positive. They are involved they have a significant international practice, and it involves giving evidence across the globe on very, very technical, usually accounting and economic type issues. They found the hearings to be both efficient and effective done virtually. So there's no more expensive, time-consuming travel. They're not in a witness box suffering from jet lag because they've had to just fly in and they need to fly out. There isn't the waiting around time. They can be in court with half an hour's notice so that they know what's a court day, but they can fill the rest of the day that they're not giving evidence with getting on with other work. So that obviously makes it much, much cheaper for clients, but they also feel fresher and more ready to give their evidence. There's also the aspect of just being able to do it in their own environment. They don't see it as any less important, but doing it in their own environment enables them to feel more comfortable with the documents around them, etc. And these are highly professional people, so that some of the risks that Charles was just talking about just simply aren't there. So certainly from the view of the experts giving evidence, it seems to be very positive. And I've acted as an advocate with expert witnesses, and their interactions with me have been more positive as well. They felt very, very comfortable in the environment.
Yes. Okay. And what's been your experience with hot tubbing? I know you sat as a judge and had experience of hearing experts in the tub, so to speak. So what's your experience of that been in the virtual world?
So as far as I'm aware, the First Tier Tribunal heard its first hot tub experts this year in February. It was a highly contentious tax transfer pricing question, where actually on the face of it, there seemed to be a high level of unanimity between the experts, but it was in the nuanced differences that the problem lay. The experts had actually never met each other physically because HMRC's expert wasn't appointed until partway through the trial because their previous expert had gone off sick. So it was a seriously suboptimal situation. And yet it was probably one of the most positive experiences. The free-flowing interaction of two expert witnesses, two counsel, a judge and a member all on together. It was properly like a meeting rather than a courtroom, but it enabled facilitative discussion that really got to the nuts of the issue. And because everybody was in that very sort of intimate proximity and yet hundreds of miles apart from each other in some situations, getting a full understanding of exactly what was in dispute and exactly what was agreed seemed to work the best it could have done. I cannot envisage a situation in which it would have worked better. You know, in a courtroom, you can't physically put two people into a box. So you've got one in the box and one sat somewhere else, and they might have that discussion, but have you got the sort of parity of importance or parity of status if one person sat higher up than the other? But on the screen in a Teams environment, it seemed to work absolutely brilliantly. So in the context of challenges, actually, I think this is the antithesis of a challenge. I think it worked really well.
And just to challenge that, do you think that it's more or perhaps less difficult to convey a series of difficult concepts in a virtual world rather than face-to-face if it requires a long, detailed, complex explanation? Is that harder to convey virtually than perhaps face-to-face?
That was not our experience. I mean, I have to, you know, make the point that statistically, a sample of one is not statistically significant, and so it could just have been lucky. Picking up on what something that Heather said about the difficulties in handing documents up, you do actually have the facility, certainly on a Teams function, of sharing documents on screen. And so actually, when you're talking about a complex spreadsheet, as a judge, somebody's talking about a spreadsheet, and I'm genuinely rubbish with spreadsheets. I almost go into apoplexy when somebody says, I'd like you to look at a spreadsheet. And of course, once you've printed it out, you also can't see the formulas in the spreadsheet. Whereas if somebody's sharing a complex spreadsheet on screen, you can click in the box, you can see the formulas, you can check that it's working properly. And so that digital interaction actually made lots of things easier, things that you would have had to have explained verbally by pointing a finger at a box that hasn't got a letter and a number at the side. You know, you're not in X2 or X422. So I think that made things much easier, actually.
Yeah, okay. Can I ask you now to put your judicial cap on as well and speak about access to justice? Is it negatively impacted by virtue of the virtual world or not?
Well, I believe it should be positively impacted because there's much greater flexibility. When we move into a world where there is optionality, you can have face-to-face hearings, you can have hybrid hearings, you can have virtual hearings. You cut the cloth to tailor the suit effectively, and virtual hearings will be entirely appropriate in some situations and entirely inappropriate in other situations. And so access should be improved. So as others have said, translated hearings are a right royal difficulty because of the multi-way interaction. But it doesn't necessarily mean that even in a virtual sense that they're necessarily wrong. And so, for instance, I sit in the social entitlement chamber, where virtually everybody is self-represented, and all of them pretty much are vulnerable. The ability for those individuals to access justice from their lounge with their child or some other responsible adult sat with them, I don't think it can be underestimated, the significance in terms of access to justice in those situations. And that'll be the same for immigration, wherever you've got vulnerable litigants in person. And that represents a very, very large part of the number of cases. It's not the sort of thing that we deal with in our professional environment, those of us on this call, but it's a very large part of the justice system.
Yeah, okay. A final question for you, Amanda, before we move on to the final theme. Do you think that there's likely to be more appeals or retrials as a result of virtual hearings? Everything's recorded. An appellate judge could have exactly the same view as a High Court judge, for example, has had, whereas at the moment, or before the pandemic, an appellate judge wouldn't have had, although they may have a transcript in front of them, they wouldn't have the beauty of a video camera and live transcript.
Litigants might try. Can't see the judges being very keen. I mean, appellate courts have a very specific role, and it is not to retry the case. I would imagine that that's going to be squished before it even takes a breath.
Yes.
No. Certainly, I mean, my particular area of expertise is tax, where you can't appeal on the facts unless you can say that it's no reasonable tribunal could have reached that view. The upper tribunal and the Court of Appeal are simply not going to want it. They just won't give permission. And there's no right of access to appeal. You have to get permission, as everybody knows. So leave just won't be given.
Okay. All right. Thanks, Amanda. So we're going to move on to the final theme of virtual mediations. And I should say this is going to be very brief. So if anyone does have any questions, please do use the Q&A function at the bottom of the screen, and we're very happy to answer any questions. But for the next couple of minutes, we're going to turn our minds to mediations, which I think are very distinct for a number of reasons from the hearings that we've been speaking about. Let's go back to the results of the survey. There's a marked contrast between people's attitudes towards virtual hearings, and particularly virtual interim hearings, and mediations. With mediations, just under 64% said they would prefer to conduct a mediation in person rather than online if they were given the option. One can understand why they felt that, but 6 months on, as we've been forced into a prolonged lockdown, what has the actual experience been? So Sarah, could I ask you, what's your experience been with virtual mediations? Was it less personable and therefore less effective, or are you a great fan of them?
We didn't really get the chance to be personable, which is perhaps a good thing. I mean, we found it, I've done a couple, but they've been very efficient. So you get together in over Zoom. So you have all together at the start for your opening statements, and then you break out into breakout rooms, with different parties in different rooms, and the mediator sort of flitting around like a butterfly between you. It's less personable. So, at a normal mediation, it's like a day of doom, because you're just stuck together in a room all day and potentially all night too, and exhausting every topic of conversation. Actually, you don't have to do that when you're on a virtual mediation. One of them, the client was in Dubai, I was at home. We're both working on other things when the mediator's not with us, but we're all there if we need each other. And so it takes some of the pressure and the sort of oppressive nature of a mediation away. But I think that sometimes will get to the settlement. So it may be all just a little bit easier for people, but actually, You know, it's not about the process is not about it being easy. The process is about it being uncomfortable and being forced to confront you know, the other side's case. So definitely do one again. I think they work well, but I don't see them being completely replaced by virtual mediations.
No, I mean, is it fair to say that really it comes down to the individual personalities, how egregious and how acrimonious is the dispute? If you've got two independent senior businessmen who have been far removed from the day-to-day dispute, who come in, who just look at it purely from a commercial and pragmatic perspective without being imbued with any of the acrimony, then it may well lend itself well to a mediation. Contrast that to, you know, two members of a family in the context of a family dispute. Is it worse to be virtual, or is it an advantage? As you said, could it take the sting out of it?
I think, I mean, you're absolutely right. Two very different types and dynamics of dispute. And in my experience, the first one usually results in quite a quick settlement because everyone just wants to get it done if, you know, if there's a deal to be done. Whereas the second are the, you know, the family disputes, the really difficult shareholder disputes, for example, they're the ones you can be there all night. And I suspect that in that second case, not being forced into the room with someone, not being forced to look them in the eye, will actually allow parties to kind of escape the sort of pressure of the mediation, which I don't think is necessarily a good thing. And
in your experience, have you been able to avoid the situation that so often happens in mediations where there is no real constructive discussion for the first 10 hours of the day until everyone gets exhausted and very hungry and tired and needs to get back to their families? So they therefore turn their minds at midnight thinking that it's worn down the parties. Is there more of a tendency to just cut straight to the chase?
I think so, yes, because you're sitting essentially in your study or in your living room, you know, and particularly this one where the client was in Dubai, you know, our 6 o'clock was his 11 o'clock or whatever. So I think everyone, you know, remote calls, all those sorts of things are just much more tiring generally. So yeah, I think it does. If there's a deal to be done, it means you get to it quicker, but you don't have that sort of relentless erosion of willpower that a normal mediation produces.
Yes. And Heather, could I ask from an advocate's perspective, I don't know if you've attended any virtual mediations, but do you think the role or importance of the advocate increases or diminishes with a virtual mediation?
Well, I've done one virtual mediation where I was in all day and one where I was sort of, if you like, on the end of the call. And I think that's one point in which virtual mediations actually allow for greater flexibility and are more adaptable, is much like you often have people like Amanda, the tax advisors, on the end of the call because you want to check the deal that's being done works from a tax perspective. I think it also allows for slightly greater flexibility in terms of counsel. You say, well, actually, we don't really need you here for all of it, but we might get you to dial in at the times where counsel often is sort of the drafting, the settlement, that rule. And so I think that rule remains, but virtual mediations allow for more flexibility in how you're going to get counsel involved, because there's a great swathe where often counsel is not needed. The mediation I did actually, which was very international, one of the clients was in Iran. So we had, again, the time difference point, and getting everyone in one place would have been difficult, was actually much more, it wasn't really a commercial dispute, it was much more sort of private wealth. And the ability to, where we didn't do a joint session or anything like that because it just struck us as something that was going to make things worse. The ability to sort of just have this very separate, emotionally distant process, I actually think helped. I would be quite interested to see a much more commercial business one, because in my experience, although they might think, oh yes, this is all about business, it's often all about the personal relationship and whether or not there's going to be any relationship going forward and the terms on which they're going to continue that relationship. And often, in my experience, the successful mediations there is about negotiating that, and those negotiations work well face to face. So I think that's one of the problems of the virtual platform, is you really lose the in-person interpersonal, whether that's with clients or the counsel to counsel chat. And that's difficult to find a workaround for. And I think it makes it more difficult for counsel in particular, because sometimes you're at the mediation to either be a Rottweiler, because you kind of want to shake the other side up, or in an appropriate manner, of course, or a shield for your client. You think your client's going to come under quite some pressure from the mediator, and you want to be there to sort of step in and deflect. And that's very easy when you're there in presence. It's often a physical thing. You interpose yourself between the mediator and your client, or you have a very sort of strong opening statement. That's really lost in a virtual mediation. You can't sort of cut across the mediator in the same way. You can't physically block or sort of strong eye the other side in the joint session, because you're just a box on a screen, and they can turn their speakers off, frankly. So I think a counsel's role is difficult and challenging, but I still think useful and present, because without the physical people there, I think clients are going to be turning much more to their lawyers about where is this going, what ought to I be saying, getting that feedback to try and recreate the sort of interpersonal that's lost by virtual mediations.
Thanks, Heather. And there's time for what to answer, I think, one of the questions that's been asked, and perhaps you're the best person to answer it as the advocate. So the question is, do you think that in the virtual world in which we're now operating, that there is less visibility in the room, and therefore it's difficult to read whether it's the judge or whether it's the opposition, or whether even it's your client or the opposing the opposing client? Do you think it's become easier or more difficult?
I think it's much more difficult. I think it's one of the reasons why virtual hearings are much slower, because you lose the sort of body language. So if you go to a hearing, most of it is you trying to work out, when you're pitching your arguments, how they are landing. Do you need to push this point further? Is this point going badly? And in that case, are you going to row back from it? Are you going to ditch it? So there's this shifting going on at all of the times when you're trying to work out how best to get your point across, and whether you're facing resistance from the judge or your opponent, and all of that. And that is completely lost in virtual hearings. And it's quite, you lose the connection with the rest of the legal team and with your client. I mean, even in the very small hearings that you do in county courts, which are obviously not the sort of litigation we're talking about now, but you've never met the client before, but the clients want to meet you. It's kind of like meeting your surgeon before surgery. Like, something's going to happen to you, and it might not be very pleasant, and you might not be awake for a great deal of it, but you still want to meet the person who's going to do it, and sort of look them in the eye and think, you know what, I trust you to do a good job. And that sort of meeting where you meet the clients and settle them and say, I get your case, we're going to take it forward, it will be fine. That's impossible to replicate virtually. And I think that is a real loss, because I think those relationships are a very valuable part of what we do.
Yeah, thank you. Well, I didn't want to end on a negative note. On the contrary, I think what we've established during this discussion, both on the results of the survey, the subsequent experiences that everyone's had, is that virtual hearings are here to stay. They're certainly here to stay in terms of your short, procedural, straightforward hearings and your interim hearings. For trials, in some instances, they may be appropriate, but there's a leaning towards returning to the in-person hearings when possible for certainly your complex commercial trials. So I think there's mixed feelings, and the same with mediations, where in the right type of case they are appropriate. I'm conscious now that there's 1 minute to go, so I'm sure everyone will thank us for finishing a minute early rather than a minute late. But thank you to the audience for participating and joining. We hope you found the discussion helpful, and we look forward to seeing you at the remainder of the sessions for today. Have a good weekend, everyone, and thank you very much.